He had actually informed Norma. We were informed by the accused that this Norma is a is a divorced attorney. The one would expect that an attorney will advise the accused well as to the fact that he should go and report this to a police station. But we did not receive an explanation with regard to that from the accused. The accused never reported any of the above to the police, and he remained in Pakmo, where he was staying during his studies. Whereas this incident was on media the very same day the deceased was murdered. During his examination in chief, the accused legal counsel added the report by Telcom Exhibit K, but did not ask any questions regarding this. Cross-examination. It was put to the accused that he did not remove the phone from the scene, as he knew it could be tracked easily. The accused stated that he underlined this could have solved the issue of the phone tracking. Accused testified that the body was almost cold when he checked for her pulse. He confirmed that he did not observe any injuries to the rest of the victims or the deceased face, the head, and neck. He also did not observe blood anywhere except on the cheek where he had seen the scratch. The state provided him with photos taken from the post-mortem report and asked the accused to comment thereon. Exhibit L. He considered that the injuries depicted on the photos were different from his testimony. He actually stated the following: it looks worse now. That's what he told us, injuring the victim's wound. However, of importance, he and that it took him approximately 3 to 4 minutes to do that. He denied removing the sunglasses and later testified that in the photograph, which depicts him in the victim's t-shirt, he was wearing his own sunglasses. The accused could not give an explanation as to why he chose to wear the victim's t-shirt. And it was put to him that he did so because there was blood on his own t-shirt. He denied this by stating that the blood would not have shown on a black t-shirt such as he was wearing on the day. The accused confirmed that it took more or less a month after the above-mentioned event before he was linked to the matter or case and eventually arrested. The accused reaffirmed that he was in the Sandton area between 9 to 10 a.m. When asked whether it was possible that he was in the area of George Lee Park around 8 a.m., he unambiguously said that it was not possible. When told that the state will prove he was at or near George Lee Park around 8 a.m., the accused stated that the photos he took, such as that of Exhibit A, were time-stamped and would prove otherwise. The state put the contents of the telephone report to the accused, who disputed it by attempting to explain where his phone was located according to the report, but eventually conceded that he does not know where the towers, specifically the one that tracked him, are located. The accused further disputed the correctness of the still photos taken from the video footage and denied that he was at or near the victim at around 5 minutes 8 a.m. When asked how he could be granted bail if he had already admitted to concealing evidence, the accused answered that he was trying to save himself at the time that he disposed of the victim's clothing, and that the situation was now out of his control. There were questions that were asked by the Honorable Court. The Honorable Court asked several questions of the accused, specifically pertaining to the injuries of the victim at the time he was on the scene. We must note that as legal practitioners, we normally call these questions clarity-seeking questions. We confirmed once more that the victim's body was not in the state depicted in Exhibit L when he left the scene. We also speculated that the victim had been murdered somewhere else and her body disposed of there. Re-examination. The accused was handed further pages from the provisional post-mortem report, added as Exhibit M by his legal counsel, and asked to read certain paragraphs, focusing on the comment by the state pathologist that there were, underlying this, no obvious injuries to the genitals. This report also confirmed that the victim was 14 weeks pregnant at the time of death with a male fetus. State case. The state relied on the contents of two affidavits, which were read into the record, deposed by Mr. Grant Mulder and Sergeant Aubrey Chisane, respectively. The affidavit of Mr. Mulder, Exhibit N, was concise and clearly sets out what video footage was obtained, and further the timeline it established of the victims and accused movement on the day of the incident. In summary, it sets out the following timeline. At 8 a.m., a photograph is taken by the MyRun timekeeper, which depicts the victim at the start of a lap. At 6 minutes past 8 a.m., a video footage obtained from a security camera on the eastern side entrance of the George Lee Park on Colt Road shows an African male with a black shirt and tattoo on his right upper arm, that is the accused, taking a photograph of the information board at the entrance to the park. This placed the accused more or less 1 minute 30 seconds behind the victim. He was wearing a black t-shirt at this stage. At 18 minutes past 8 a.m., the victim's cell phone is picked up by another participant of the race and handed to the timekeeper. At 49 minutes past 8 a.m., the video footage obtained from a Sandton school camera views the western pedestrian security gate to the park and shows the same African as above mentioned leaving the area. At this time, he was wearing a blue t-shirt and carrying a black bundle. At 52 minutes past 8 a.m., a video footage obtained from the camera at number 89 Olympia Avenue shows the same African male jumping over a closed gate at or of George Lee Park. A further video footage was obtained showing the accused disposing of the victim's clothing in the storm drain at number 125 8th Street, Parkmore in Sandton. Sergeant Chisane, the investigating officer, also deposed to an affidavit in which he set out how the accused had been traced and the grounds on which he submits that the accused must not be released on bail. Analysis of the evidence comments on the applicant's closing argument and the applicable law. Let's look at that. 1. The defense presented a commendable effort in arguing for the accused to be released on bail. However, no amount of overturning every stone, objections, disputing of facts, or attempts to cross-examine an affidavit will change the fact that the question this honorable court needs to ask itself is simple. This is the question. Has the accused proven on a balance of probabilities that he has exceptional circumstances that will justify his release on bail? After approximately 20 hours worth of presenting evidence, arguing, or making submissions, The defense has attempted to make the issues before this honorable court as clear as mud. The purpose of the state's submissions is to clear the air, not only for the honorable court, but also for the media, for the general public, who have taken a keen interest in these proceedings. The defense has submitted that the accused should be released on bail as he has succeeded in proving exceptional circumstances. Their argument, which were covered at length and then some more, can be summarized as standing on two legs. The first leg is that the accused has taken the honorable court into his confidence by disclosing his defense by way of presenting viva voce evidence and thereby submitting himself to cross-examination. And the second leg is that the state case against the accused is weak. The defense even went so far as to confidently submit that if this was a trial, they would have brought an application in terms of Section 174 of the Criminal Procedure Act, that is, to make an application for the discharge of the accused. They went further and stated that they will be making representations to the NDPP, specifically Shamila Batoni. The state submitted that does not fear anything. There are quite a number of cases that were taken to Shamila Batoni, and they were brought back to us where the decision of the lower office of the NPA was confirmed. It is respectfully submitted that the defense has erred in their submissions, in that they are either oversimplifying the issues before this honorable court, or they are willfully ignoring the evidence presented by the state and the accused himself, stating that there is no prima facie case against him. We are referring to admissions. It is respectfully submitted that the accused, despite claims to the contrary, did not take this court into his confidence, and that he has, in fact, been selective with his evidence, only in an attempt to claim, now during closing argument, that accused was playing open cards. Where admissions were made, it was done because he knew, likely after being advised by his legal counsel, that he had no grounds on which to dispute certain facts. To illustrate the above, the following submissions are made. The accused testified that he had been informed at the time of his arrest that the state was in possession of video footage which linked him to the crime scene. The accused was further informed that the same footage clearly showed him wearing a t-shirt of the victim on the day after her death. Sometime after this, the accused came up with a seemingly plausible explanation for his presence at the scene, and even went so far as to concoct a version which would explain him removing the clothing of the victim. The accused version starts to strain itself from the onset, in that he testified and stuck to his initial version of events, in that he had only entered the Sandton area between 9 to 10 a.m. This version was refuted by the telecom reports, which placed him in the general vicinity of George Lee Park at 7:35 a.m., almost an hour and a half earlier than he testified. It was then further refuted by the video footage, as set out in the photographs and affidavits, Exhibit N and P respectively, which placed him at the gate of the park at the same time as the victim when she was still alive. Then the accused dug himself into a deeper hole by testifying as to the condition of the victim's body when he fled the scene, specifically referring to the injuries. The accused considered under cross-examination and when being questioned by this honorable court that he had only observed a scratch on the cheek, swelling on the neck, and some minor scratches over the body of the deceased, and that this was still her condition when fleeing the scene by the accused. He further confirmed that the injuries depicted in Exhibit L were not present at the time. Let's look at this. Try to look for answers. This would mean three alternatives are possible. The first one being the following. Despite his testimony that he truly checked for signs of life, the accused must have erred, and that the victim was actually still alive when he fled the scene. We must note that the accused is not an expert in what he was doing. He was basically guessing. This would also mean that the victim had not made any sound, no movement, or taken a breath whilst the accused was removing her clothing. And by logical inference, her entire body, a process which the accused testified lasted a little under 10 minutes. The state will submit that this is highly improbable. The second alternative is that should the version of the accused be accepted, and that the deceased was indeed deceased when he fled, in brackets, only suffering the scratch on the cheek, swelling on the neck, and few scratches over the body, it will mean that the bruising on the victim's face, as indicated on Exhibit F, would have been inflicted after her death. It is respectfully submitted that this possibility is medically impossible. And this honorable court is experienced enough to take judicial notice or cognizance of the fact that dead bodies cannot be bruised. The third alternative and most probable answer to this is that the accused is misleading this honorable court as to the state of the victim's body when he fled the scene, and that she was in fact in the state as depicted in Exhibit L when the accused fled. It is submitted with respect that the only reason the accused will be untruthful about this aspect is because he was the one who inflicted the injuries which led to the victim's death. Evidence to this extent will be presented during the trial proceedings of this matter. If one takes the admission or admissions made by the accused during the Viva evidence, together with the objective evidence presented by the state, being 1, telecom report, 2, video footage or still photographs, the provisional post-mortem report, as well as crime scene photos, it all points to the fact that the state has a prima facie case against the accused, and that his version has only raised more questions than it had or it has answered. The defense has submitted and will most likely do so again in their reply, but there are numerous other possibilities as to what could have befallen the victim. However, the principle of Occam's razor states that the simplest answer is most probably the correct one. In a preemptive response to such an assertion, the state will refer this honorable court to the case of Barnes and another versus S. It's a 2023 matter. It's appearing in the sense of argument, where it was said at paragraph 9, a principle that requires particular focus in this appeal is that a bail application is not a crime. The second matter that as a state would like to refer this honorable court to is State versus Branco, where the court held that a bail application is not a crime. The prosecution is not required to close every loophole at this stage of the proceedings. Let us also look at, or the state will also refer this honorable court to S versus Philbune, the 2002 matter, SACR 550. At 25, Judge Olifield states as follows: that care should be taken not to turn every bail application into a drawn-out trial before a criminal trial. Without answering to each and every submission made by the defense ad seriatim, it is prudent that some general comments by the accused legal counsel are addressed by the state. That's the reason why the state requested for the remand. 1. The PM report. The accused counsel submitted on several occasions that Exhibit M, being specific pages from the post-mortem report, will in fact exonerate the accused. It goes without saying, but it is still worth pointing out that the report is clearly titled Provisional Post-Mortem Report, with the operative word being provisional, which implies that it is not a final report. It is submitted with respect that this report was only obtained, as is the practice with such investigations. That is to establish the cause of death and to assist the state with regard to preliminary examination of the body in question. Furthermore, the accused legal counsel insisted that their client read in the paragraph into the record relating to injuries to the genitals, which read no obvious signs of genital injury. Let's look at this. Despite this, they still, that is the legal counsel, ignore the important word, which is obvious, which together with provisional implies that further examination needs to be done. This comment does not exclude any kind of sexual violence inflicted on the victim. And to rest your laurels on this point will be premature. Taking this point further, that paragraph of the report does not say the deceased was not raped. It is important to note the objective of that report. The only person that can comment on whether the deceased was raped or not is the district surgeon. One is not supposed to be excited by the following, that there are no obvious injuries. As legal practitioners, we know very well that when one is charged of rape, it is not only, or let me put it in this way, the question of injuries is not the only element that the state will need to prove. We must note that as we are proceeding with these matters, I'm talking about rape, as a state, there are a number of things that we need to establish. One, how many times did the victim have pregnancies? Second, we also look at when was the last time before the victim was raped, did the victim engage or was involved in sexual intercourse? It's not only about the injuries, as the defense was excited. They took great pains to bring the timeline presented through Exhibit N and P. Before proceeding with the Sandton section, lastly, let me just submit, and I'm submitting with respect, to say that because there were no injuries, there was no rape, it was actually misleading to this honorable court. They took great pains to bring the timeline presented through Exhibit N into question. However, they again willfully ignored the fact that the information therein is based on a video footage, reports, and affidavits, which will be disclosed to the defense once investigations are complete. Their refusal to accept it also does not negate its evidential value, nor the fact that the accused could not give satisfactory answers as to why his version is so substantially different. The legal counsel for the accused also made what we call a Hail Mary attempt in this regard by submitting that Exhibit M contradicted the timeline by stating the time of death was 30 minutes past 10. The fact that this is also contrary to his own client's version seems to be irrelevant and exempt from logic. Still, with the disclosure of charge sheet as well as the docket contents, it is tried law that the state as dominus litis has authority to present charges to an accused that it deems fit, and that this can be changed until such a time as an accused person pleads thereto. As the court made a ruling in this regard, specifically with regard to the schedule of the offences, this point will not be labored further. Suffice to say that the defense is trying to have another bite at the cherry, as the allegations and evidence submitted to the court fall within Schedule 6. Furthermore, it is tried law that the defense only becomes entitled to copies of the docket upon finalization of the investigation. Therefore, it logically follows that the accused who opts to bring a bail application without knowing the docket contents do so at their own peril. This is an inherent risk that has been the practice and law for many years, and that the defense now cries about unfairness is what is without merit and should be dismissed. And furthermore, it is the prerogative of the state to use the docket contents as evidence during a bail application if it deems necessary. That is the state. The defense is not entitled to more than that, and the submission to the contrary should be seen and dismissed for what they are, truly are. A near fishing attempt to obtain early disclosure of the docket contents. I'm saying this without fear of failure. To illustrate this point, one need only to look at the case of Matebula versus the state. This is a case on a number of incidents we heard about from the defense. However, it was important to note from the side of the state that the defense was using a strategy of picking and choosing. They will choose what is favorable to them, and will not hear anything which is against them. Let's look at the follow-up in this case. At paragraph 12, I quote, "The state is not obliged to show its hand in advance, at least not before the time when the contents of the docket must be made available to the defense. Nor is an attack on the prosecution case at all necessary to discharge the honors. The applicant who chooses to follow that route must make his own way and not expect to have it cleared before him." The very same particular case. Let's look at another case. In the case of Dlamini, it's a 1992 SACR matter, constitutional court matter. It was stated that an applicant for bail is not entitled to access to the police docket for the purposes of bail proceedings. Let's also look at section 60, subsection 14 of the Criminal Procedure Act 51 of 1977. They say that this section also bars disclosure for purposes of bail proceedings. This is the state answer to an application that was made at the beginning. Surely this is clear now for the defense. No more cries. Cross-examination of state's affidavit. The defense once again, during closing, raised cries of unfairness that they were not provided with the affidavit used by the state in this application prior to be reading into the record. It is submitted with respect that it is common practice not to provide any applicant in a bail application with the state's evidence prior to its submission. A practice it is submitted that the defense is well aware of. And the only reason to raise this as an issue is once again to distract this honorable court from the main issues currently before this court, especially that main question. We concur, however, with the defense in that the rules of evidence during bail application are relaxed, thereby allowing hearsay evidence to be led. However, to claim that each and every detail should be stated to the extent that the defense submitted would amount to the absurd and be unnecessary for purposes of bail application. Again, it is submitted with respect that this was an attempt to downplay the value of the state evidence in light of the accused admission. And generally, the state would concur with the defense that the evidential value of the Bafana evidence outweighs that of evidence led via affidavit. However, this is only true when the Bafana evidence can withstand the scrutiny of cross-examination and further is not rebutted by objective evidence. It is respectfully submitted that the accused's disclosure of his version was selective, misleading, and most importantly, not supported by other evidence. And it in fact it was contradicted by objective evidence as stated here in above. The state will refer in this regard to a comment that was made in Matebula at paragraph 11. In the present instance, the appellant's tilt at the state case was grounded in several aspects. First, they founded an attempt or the attempt upon affidavit evidence not open to test by cross-examination and therefore less persuasive. Second, both the denial of complicity and the alibi defense rested solely on his say-so with neither witness nor objective probabilities to strengthen them. The vulnerability of unsupported alibi defenses is notorious, depending as it does so much upon the court's assessment of the truth of the accused testimony. The defense concluded its lengthy address by commenting that no evidence has been produced which justifies the refusal of bail. However, it is right that the burden of proof lies on the applicant during the Schedule 6 bail application, not the state. General principles regarding the Schedule 6 bail application. The Honorable Court is well versed in the relevant case law regarding Schedule 6 bail application, and the state will therefore keep the submissions on this point brief. It is, however, necessary to answer certain submissions raised by the defense. In As versus Mabena, at paragraph 5, it was stated on the topic of depriving of an accused person's liberty that a reversal of the general rule was held in Dlamini to limit the constitutional right to bail, but the relevant provisions, that is Section 60, subsection 11A, survived the declaration of invalidity because the limitation was held to be reasonable and justifiable in terms of Section 36 of the Constitution in our current circumstances. There is a plethora of case law on the topic of what constitutes exceptional circumstances, but the state will not repeat what the court and the defense are well familiar with. However, in Tlapo versus S, which is an unreported case, at paragraph 5, it is summarized perfectly by stating, our courts have had occasion to deal with what is meant by exceptional circumstances. It is clear from the said cases and in the cases quoted therein that exceptional circumstances mean more than what can be described as the run of the mere bail application. An applicant for bail that faces a Schedule 6 charge is expected, in my view, to present more than that he or she will not interfere with witnesses or will stand trial. He or she must present cogent evidence that can stand up to scrutiny and convince a court on a preponderance of probabilities that he should be committed to bail. It is respectfully submitted that accused personal circumstances in itself does not constitute exceptional circumstances. And as stated in Matibula, paragraph 15, it was stated as follows: parroting the terms of subsection 4 of section 60, as he did, does not establish any of those grounds without the addition of facts that add weight to his ipsa dixit. It is further submitted that the submissions by the defense that the state case is weak and that the accused took the court into his confidence does not lend weight to the submissions regarding exceptional circumstances. General comments. We are well aware as a state that at this stage we are not proceeding with a trial. That is a hearing to determine the guiltiness of the accused. There is no need on our part at all as a state to prove our case beyond reasonable doubt. All that is needed from the state is to show on a balance of probabilities whether there is a prima facie case or not. With regard to this, we refer this honourable court to a case of Conradi versus S. It's a 2020 matter. The court stated at paragraph 20 as follows: a court says of bail application fulfills a very different function from a trial court. Its role is not to determine the guilty or innocence of the accused person. The bail court is concerned with the interest of justice in the sense of weighing in the balance the liberty interest of the accused and the interest of society in denying the accused bail. Will, however, in most cases entail that it will have to weigh as best as it can the strength and weaknesses of the case against applicants for bail. A presumption in favor of the bail applicant's innocence plays no part in that or in this exercise. Let's also look at the case of Mafe versus S 2022 matter. The Honorable Justice Lukulin stated in paragraph 143 as follows: the state, on the other hand, must show that, notwithstanding the accused presumption of innocence, it has a prima facie case against the accused, enriching a value judgment in bail applications. The court must weigh up the liberty interest of an accused person who is presumed innocent against the legitimate interest of society. In doing so, the court must not overemphasize the right at the expense of the interest of society. The state will submit with respect that it is or it will be the interest of the society that the applicant be kept in custody. The state will submit that it is of the view that it has been able to establish a prima facie case. One of the things that this honorable court will have to look at is the following. The state will submit and with respect and argue that one of the options that the state was faced with was whether to proceed leading evidence. The state is of the view that with the admissions of the applicant, only prima facie is established. The state just felt that it must also do its work. But the state is saying that there is a prima facie case, there is a case. And as such, there is no reason, there will be no reason for him to be released. Conclusion. In summary, it is respectfully submitted to the state, by the state, that the accused has failed to prove that exceptional circumstances exist which permit his release to be. No evidence was led by the accused to prove that his personal circumstances are exceptional. Where admissions were made by the accused, it was done selectively and with the intent to mislead the owner court, so that he can now claim at the conclusion that he took the court into his confidence. This is based on the submission that the state has presented objective evidence which, when necessary, contradicts the accused version, thereby leading to the only reasonable conclusion to be drawn is that he was misleading his own court. For the above reasons, the obligation should be, obligation by the applicant and by the accused should be dismissed, and the accused detained in custody until the final resolution of this matter. It will be may I just ask for a minute? With regard to other submissions made by this defense, the state is of the view that they were not relevant to the question that is before this court. And the state will not waste its time in this court by answering to the so-called allegations, except just to mention the following. One of the defense that is raised by the applicant, or one of the points that is raised by the applicant in his defense, or in his version, is that he was afraid or so scared after realizing that the deceased was a white person. He informs us that in this country there's this competition between black and white. The state will submit that it does not know that. As far as the state is concerned, the deceased is a human being, and she must be treated with respect. Competition that the applicant referred to maybe is taking place at Omalanga only. Last week we just had a committee, the 15, which we have never had before, due to the fact that Mapogogo win. A team that is constituted by black people. The state will pray and humbly request that that should be dismissed, should not be actually treated with the leg to stand on the top.
Mr. Masako.
Your Worship, I will address, even though exhibits as promised have not been given, and we can safely say for now, M1, M2, and one affidavit of the IO were not furnished to us. And we humbly pray and not be dismissed. But without any waste of time, let me start with the conclusion, which reads as follows. Accused to be kept incarcerated until finalization of the matter. date thereof is not being given. How long investigations are likely to take, we do not know. And all that is in the hands of the state, not in the hands of the accused. But we are told earlier on the only ground we brought for the refusal, the only ground we brought for the only ground we brought for the release of the accused is that the state case is weak. Now they have now arisen another ground. The investigation are incomplete. And it's in line with what my learned colleague said in his opening. Matter is still under investigation till thy kingdom come. That's the point. Be kept in custody till thy kingdom come. Why? We don't know. And the Constitution is very clear that limitation of rights has to be reasonable and justifiable in the circumstances. This is a very quite disturbing proposition by my learned colleague, in that he shows either misunderstanding, a gross misunderstanding of the Constitution, or lack of appreciation that the Constitution is the supreme law of this country. But I'm not going to get into, but I was just hinting that there is another ground, and it is not proper that we raised the weakness of this case as the only ground. It is not right to say that. As if I was anticipating as to how much my learned colleague was going to attack me, and I decided, let me just draft. And learned colleagues were asking me, how do you know what is it going to say? And I said, no, let me draft as broad as I can to ensure that this court is given a proper perspective. Not all this wishy-washy which we see in this court. Now, I have prepared a copy for the court, which I'll hand to the court. Now, I've prepared for the defense because we don't believe in trial by ambush. And I'm not a crying or lamenting type. I've been in this practice for long. I've seen it.
Humbly approach, Your Worship.
Certainly.
I've seen it. I've endured pain, suffering, anguish. This is absolutely nothing to me and my client. But we are simply saying equal justice and sympathy, and I repeat. Worship will realize that our heads have an outline which is at the top. May that be confirmed?
Yes.
The outline, and there will be a rebuttal, applicant's rebuttal argument. And then you should realize it has a section A, but I added B because I was trying to find my feet. Worship will take into account that at the time of drafting these heads, the heads which are presented to me now were not in our post. And I'm not in any way suggesting that I was entitled. There's no rule that says that. Now, let me first explain the outline. The outline will show the purpose of our rebuttal argument. B, the things or issues that troubles the defense. C, merit, weak or strong prima facie case, viva voce case, and will refer to a case called S versus Shabalala. Risk of self-incrimination, and in bracket, such risk of self-incrimination as may have existed was a risk which we should have run in the circumstances, and we endured. Close bracket. And then one can look also at page 107, which I'll refer to if it arises, of a bail practitioner's guide, which my learned colleague didn't even touch. This is a very important source when you're dealing with bail. If you don't know Dlamini, and if you don't know this book, then you're swimming in wrong seas with the sharks instead of the dolphins. This book is the Bible of the bail chapter. My learned colleague never, even on the advice of other people who are assisting him, never cited it. And it is the Bail, a Practitioner's Guide, 3rd edition, Johan van Berg. And I'll refer to it. Now, I'm back to the outline. D, prosecutors and police. And I'm saying we'll submit that this relationship is an unholy union in the holy period of Christmas. E, prosecutorial discretion and role in criminal proceedings. Page 120, the bail guide again. We refer to Kamikel versus Minister of Police and Security, 2002-1, SACR 79, Constitutional Court, which placed the duty on prosecutors to bring such relevant evidence to the court's attention on pain of being held liable if a failure to do so leads to an unjustified release of an accused and the damages suffered by members of public in consequence thereof. In other words, explaining the issue about the delictual claims which will arise. And even in this one, we will show that there is a delictual claim and it will be pursued without any doubt. F, exceptional circumstances and the issue in bail hearings. I'm told that I'm raising irrelevant issues and so on. It's okay. But that comes from page 98, and I'll show that I know this case far much better than any other person. And the person who authored this heads of argument with the greatest respect was not in court, had snippets of this case, does not know this case, and is busy with one eye guiding the blind. And we say, my learned colleague, even in his address, never dealt with section 48 to E, the likelihood that he will commit, the likelihood that he will do this, flee, disturb, nothing. Is this unopposed? And if he did, we're going to answer by saying, a mere unsubstantiated fear or suspicion that the accused will commit such further offenses is insufficient to warrant the refusal of bail. Such allegations must be properly substantiated by evidence or material from which an irresistible inference of the accused's propensity can be made. And that deals with section 6042A. We are not merely referring to a mere possibility. And I refer him to S versus Fori, 1973, 1 SA 100 Devon, 101 to 102. Now, at least I have given an outline. Now let's get to the applicant's rebuttal arguments. And as I have forewarned, they're divided into the introduction thereof has an A and B section. Now, we open by saying, closing argument is very important by virtue of its location in the trial process. Some authors concluded the following. The closing argument is the lawyer's final opportunity to give perspective, meaning, and context to the evidence introduced throughout a trial. And then I close this quote. Now I mentioned, as if I knew, that after listening to my learned colleague, the defense is convinced beyond a shadow of doubt that the charges are meritless, baseless, ill-founded, utterly false, and malicious. They are also a breach of the utmost good faith. In addition, we are boldened to submit prematurely that on the preferred charges, there are no prospects of conviction even after results from forensic laboratory. Why do we say this? To say the report which is being given is interim and what have you, that's the report which they used. And even if they were to concoct, fabricate, manufacture another report which does not, which negates this one, they have a problem. Which one is, in the trial, we're going to show to the court that we are sitting with two contradictory results from the state And I need not to remind the state that the records of the bail hearing can be used in the trial, as it were, by mere producing this bail record. They're out. They're out. Now, we further say what's happening here is a farce informed by delusional mystery. I continue to read the B section thereof. The B section deals with the things that troubles the defense. And I want to speak of it frankly, for many honest men would ask, why are we not having the testimony of a witness who saw it or heard it, and the lack of direct evidence? The circumstantial evidence will not assist much in this bail application, in the absence of above-mentioned witnesses. We also submit as follows. The crimes of murder are committed every day, and they're committed by stealth. They're committed in secret. The traces of them are hidden. Murder is the work of stealth and craft, in which there are not only no witnesses, but the traces are attempted to be obliterated. And yet murder must be punished. Circumstantial evidence is nothing in the world but that presentation of circumstances from which one is irresistibly driven to the conclusion that a crime has been committed. We have been given so many alternatives. And my learned colleagues who wrote, because my learned colleague was just reading, my learned colleague who wrote knew that there were even more than 3, because in their own words they are saying the defense would head on. And I'll deal at great length with what they're saying. Let me deal with my case first. I make an example of O.J. Simpson. Stealth, secrecy, circumstantial, well investigated, not like in this case. And if they had direct evidence, then the question to be asked is, why did they not challenge the evidence that my client said they were beating him, hitting him, forcing him to make a confession that he is the one who committed? If they had their own evidence, why did they do that? They were trying to suck, to at least say to the family, he even confessed. Upon realizing that they are not achieving their goal, aim, objective, they subjected him to something which is gravely unconstitutional. Interviewed him without having any attorney, beating him because they couldn't draw at least something positive to help their case. Do all these things which are a shame in the New South Africa, which are just a violation to the Constitution. Now, my little colleague says, my client talks about, I got a shock because it was a white lady and so on. And we know that in South Africa about a white lady, and yes, indeed, it's a plausible explanation. To him, he's from Middleburg, Sandton. It's something new to him. And if he says that's only happening in Middleburg, he must also tell us when was he in Middleburg. Because it seems he knows better than we do. We submit as follows. Racial prejudice today in South Africa is subtler. In other words, it's hidden and more difficult to detect. No one from the state was going to take that stand and admit, yes, we discriminated against him. No one. And we can jump as high as we can. The race issue is still an ugly problem in the country, and some of us are representing Bafana Mahungela to cut its ugly tail, to cut its ugly face. We hate it with the greatest passion ever. If Bafana Mahungela has committed this crime, let him stand for his sins. But if he has not, why does he have to take flag for someone else? Cannot. Because he happened to be at the wrong time at a particular place called George Lee Park. As if George Lee Park was meant for Geen Blankers. We are not living in that era. He is supposed to be there. He has a right to get in there like any other public person. He has a right to walk, freedom to walk in that park. He has a right to even go if he sees a rat. Curiosity which kills a cat says to him, go and check. Is it a sin to do that in this country? And then is it even worse a sin to open this rack only to find that somebody whose pulse, whose breath, who's basically dead, to realize that this person has died? Is it a sin? We submit not. Any other person, be it of the pink color or gray color, could have sinned. So, and like any other green or purple color person can panic, panic does not deal with us in the same way. So we shouldn't try to criticize because we're not under that pressure and become cleverer than Bafana Mahungela, because perhaps, who knows, some of us could have even collapsed there and fainted and found on the scene with our spectacles fallen down on the ground. We continue. My client testified that he did not try to obliterate but accounted and disassociated himself with all the alleged crimes. The question for the Honorable Court is, who is telling the truth and who is lying? Is the story told by Mr. Mahungela, does it ring true? Does it, in the light of all circumstances, make the court to say, I believe him? Or does it leave the court with a little uneasiness? And does it, on a further reflection, make the court to say, no way, impossible, incredible, I don't believe it? Taking into account that he got in there. When he testified viva voce, we did that deliberately. We did that deliberately, and we are aware that under normal circumstances, bail applications are done on affidavit. But we are in this court. We realize that the charges as they stand, they're graver offenses. It is about a white person in South Africa, and we are in an Alexander court. And if we were to tender an affidavit, it was going to be an exercise of exchanging some kind of books and bail to be dismissed. Because he had to answer on disputed facts. He had to explain to this court the chronology of events and clarify. And indeed, the court, after the state had asked questions, the court asked clarity-seeking questions, and he answered without any doubt. But by testifying in the box, we didn't mind being at our peril, as my learned colleague said. We said to ourselves, we are going to dispense with the right to self-incrimination. We said to ourselves, we're going to dispense with the right to silence. We don't have a duty to assist. But to show that my client had nothing to fear, got in there. Now, at some point, my learned colleague says the following: evidence, viva voce evidence supersedes or outweighs any other evidence, but it seems he says not in this case. He refers to contradictions and what have you. If there were contradictions that are immaterial, we should remind ourselves that we are not in a trial court. The only version which is before court via viva voce is that of Bafana Mahungela and no one else. Now, we indeed cautiously elected viva voce evidence and not affidavit, as I said, precisely to resolve questions and for the court to know what our client was thinking, to understand the surrounding circumstances, and to draw inferences as to what his state of mind was at the time engaged in the act in question. Now, obviously, we opened up the top of our client's head. The affidavit in this bail application would have been a fiasco. Indeed. Now, if we say there are contradictions, did we put a version which negates that of Bafana Mahungela? If one looks at the cross-examination, for most of the time, it didn't achieve anything. In fact, it was an exercise repeating the examination in chief, save for producing the photos when which were showing the deceased in the laboratory. They didn't achieve, the cross-examination didn't achieve much. But we say, submit the oral evidence did provide an innocent explanation consistent with his innocence. He accounted how accidentally he arrived at the scene at the sport club and gave an exculpatory version, which was unchallenged. I remember vividly asking, when you left Alexander, did you have an intention? When you were in Sandton, do you have an intention to murder? Nothing. When you arrived at the Sandton Sports Club, intention to murder? No. I even asked him, when you met the accused person, did you know her before? He says it was for the first time. Now, where is the premeditated and pre-planned? My learned colleague said absolutely nothing about this pre-planning and premeditation. The version which stands before this court is that indeed on that particular day, my client met this deceased. Oh, I should also interpose by saying they, on their own version, produced a photo where they're saying it is this accused entering the premises of Sandton Sports Club. Where is the wreck? Where is this unknown blunt force object? They must show it. We cannot infer these things, that things we do not see on their photos. Then, if they don't have the direct evidence, then we should infer. Did he hide it? No one says he had it and he hid it, concealed it. There's another photo where they show him standing at the board. We didn't object for a simple reason. They were setting up their own trap. That photo shows him at the board. No wreck, nothing. No weapon, nothing. But instead, our client says about the time and any other thing. You have my phone. I cannot tell what time precisely it was. I refer you to my phone. Their mum on the issue on the phone. Because why? Exculpatory. We will recall that the heads of argument are talking about something new. The ground for refusal, according to the IO, is that the accused stays 1.4 kilometers away from where the deceased stays, and therefore could be stalking. What is that if it's not speculation, conjecture, and trying to draw water from a rock? Quite impossible, unbelievable, incredible at best. The state opposes the bail application we submit further and bases its opposition on two affidavits. They said they will get the private investigator affidavit. We're still waiting. The private investigator is still coming. The private investigator is still drafting. The private investigator is still pondering. Let him come. We are waiting. It's unfortunate that the bail application is on an urgent basis. We would have waited for him again till thy kingdom come. Now, is that not misleading the court to say you have a private investigator's affidavit, then you come with the securities? I'm not going to even belabor this point. Rep ipsa loquitur. Facts speak for themselves. In Latin, so they say. So, my learned colleague, that's why I'm saying somebody who drafted this has no idea about this case. Has forgotten to mention that 1.4 kilometers, but also mentions that we provided an alternative address. The alternative address, and in any way, even if we were to stay 1.4 kilometers away, the most unfortunate and sad thing is murder has occurred. And still, the fundamental question is, both the security and the IO, I'm not going to get into that. I submit as follows. They predicated their case upon this affidavit, despite the fact that they have a bunch of anomalies, a bunch of strange things. I've already analyzed them, but now add that. Now we know from their own lips that they lied, falsifies, and deceive the court. Further, while carrying a symbol of truth, in other words, being under oath, honesty, beauty, a symbol of the faith, they lied, deceived, and falsified at the same time by the prosecutor and the IO and some other extra parties. And we further submit, no code of morals can condone a lie, deceit, and falsehoods for any purpose. They're acting against the oath which they took. It's a shame. Because under oath they say, I shall tell the truth, nothing else but the truth, and help me God. But they are saying God must help them to deceive, lie, and mislead the court. We humbly submit that the state case and version for the facts came from their imagination than the testimony. State witnesses have a natural affiliation which is biased to their imagined story, like in this case. Their version is unimpressive. Testimony on affidavit is contradictory, untruthful, and unreliable. On the other hand, during their entire argument, my learned colleague could have at least dealt with issues about justice and fairness. He doesn't say a word about justice and fairness because they don't feature. But if he knew, bail applications have to do with justice, fairness, and the truth. And you can't have fairness without the truth. Unless the truth has been told, then fairness will prevail, and nothing else. My B part concludes at that. Let me deal now with authorities. I wish to state something by Oscar Wilde, but I'll deal with it. Let me deal with paragraph 2 on page 3. Right, page 3. And I quote the learned Prof. Ellison Khan in Law, Life and Laughter. He says, one owes respect to the living, to the dead one owes only the truth. That's his quote. Now my object in rebuttal is to avoid hating the living, and if I do so, I ask to be pardoned in advance. Now, after a lengthy critical analysis of the contentions by a learned colleague, our rebuttal deals with the following. 2.1 concerns that the adversary could not adequately respond to questions that they ducked because answers favors the applicant, or my willingness of my opponent to stray from objectivity. 2.2 I do not stand up here before you, Your Worship, to correct minor errors, nor to rehash my main argument, but to attack misstatements of law, fact, and evidence. And if need arises, I'll distinguish authorities which my learned colleague relied upon. I will also deal with the gloss overs in my representation, and yeah. But let me, without any waste of time, proceed to page 3. Paragraph 3 reads, and I quote from an unknown source: all is riddle, and key to a riddle is another riddle. Close quote. All is a riddle, and key to a riddle is another riddle. Why do I say so? I refer this honorable court to an authority in 3.1. S versus Zwele Tumtetwa, Western Cape, Cape Town, case numbers CC 03-2014. It was decided on the 16th of March 2014. It is a case about an internationally acclaimed artist who was sentenced to 80 years behind bars for the murder of 23-year-old sex worker. He kicked a defenseless sex worker more than 60 times, had paused during the attack, and continued, and continued. And that was indicative of his lack of respect for the bodily integrity of the deceased. Now, I'm dealing with a CCTV footage, which is the silent witness to murder. The judge will say something about that. Paragraph 70, Judge Goliath says the following: with the advancement of technology, closed-circuit television, in brackets CCTV cameras, in public places are now a worldwide feature. As a result, the production of electronic evidence in the form of CCTV footage has progressively become an important source of evidence in criminal proceedings. As a silent observer, CCTV footage can play an invaluable role in collecting evidence in search for truth in criminal trials. And even in bail applications, I would add, it's my emphasis. It has the ability to accurately capture, in an objective and independent manner, evidence in a case which can effectively establish the guilty or innocence of an accused. That is why earlier on when we started, people need to familiarize with themselves with the authorities before they criticize some of us. I refer this court to S versus Green again. The issue about Shabalala and the bail discovery of documents is tried. Can't ask for the docket. But where state relies on video footage, That is crucial because it will be indicative as to whether the state has a strong prima facie case or not. And it will also be inculpatory in that it will assist the court to realize that it is you who is wielding this weapon on this person. It is you who's robbering with aggravating circumstances. It is you who's doing rape. In this case, Goliath, what the Honorable Court is saying, hits deaf ears. They don't know this authority. And they claim that I'm ignorant. It's fine. With my ignorance, I have done, and I respect the fact that they recommend me. And I do not charge anything for that. In this case, I refer the Honorable Court to what the judge said. On page 9, there will be paragraph 22, some line at the bottom says, producing the video and the statements would not have led to a dress rehearsal of the state case and would not have prejudiced the state in any way. On the other hand, if the appellant's evidence, which had not been significantly challenged in cross-examination, was correct, Superintendent Malapo's evidence, now we would be knowing as to who is telling a lie and not. So I said, and I repeat what I said, S versus Green is an SCA case. And we cannot, for some reason, think that the law doesn't develop, it stops at Dlamini, and we think that we've got relevant authorities which are really casting any doubt. In fact, they tell us to be, gross ignorance. We are just ignorant to the core. Don't know as Mrs. Green. Now, Judge Goliath echoes the same sentiment. I proceed to read. This approach by the SCA in Tetwa was confirmed by the SCA in Long 2010, Volume 2, SACR 419, SCA, Para 22. At paragraph 72, Court says the departure point in terms of possible incrimination that Patricia Goliath referred to CCTV as direct evidence connecting Tetwa's car parked near the crime scene. And the security. There's talk that been shown. What inference can be drawn from that? Two, not many. It's either they don't have the video footage. Two, the video footage is still to be manufactured, concocted. And we are totally aware that there's an IT specialist in the crew. Related to what I had submitted, it means the cooking is still on. The pot is still boiling on the stove. The food is not yet ready. That's why they cannot dish it to the court. And we are saying even now, may court even adjourn for an hour. Sandton Sports Club is not far. We can adjourn for an hour, let them go pick up the CCTV footage. And we are saying without any doubt, they don't have it. They don't have 6 of them. Now in the absence of the 6 not being there, what must they do? Plant someone. Place someone, because a question was asked about the photos. The other one has a shade and the other's not, and trees. And when asked, Malene was very quick. No, that will deal with at the trial court. Don't worry. Another question was asked. You said she was running with other people. Where are they? No, don't worry. We will deal with that, and your advocate will mark it. Something like that. I mean, really, that's being irresponsible as a prosecutor called Dominus Litis. Proceed. On the issue of the car keys and the phone. Now, let's look at the affidavits. Really, it baffles you. A well-seasoned prosecutor comes with a version. As to on what basis is it based or grounded, we don't know. You confront my client, and I didn't object because I knew he, again, doesn't help me much. You didn't take the phone because you were fearing that you will be tracked. Can someone ask such a question in a cross-examination? You left it. The answer to that shoddy question is as follows. Why would I take the phone? Because I have my own phone, which the police confiscated. I'm not poor. He said so. I was not there to steal anyone's. But he is charged with robbery with aggravating circumstances. But about the keys is not being asked. Why didn't you take the keys and drive the car? Because if she knew her, she could have known what car is it driving, where is it parked, when was it parked, and who parked it. Left them there. Now, all these inferences which they want this court to arrive at, I know they want to come with some R versus Blom by some backdoor. We know that inferences to be drawn should be on proven facts. Now, which facts are proven here? They have to tell us. Which facts did they prove? By saying there are contradictions, is that proving a fact? No. We submit. The car has a tracker. They don't know at what time her car was stopped, and so on and so forth. But I have relied on, as Mrs. Mteto in the Western Cape High Court, I've relied on also Mlongwa case, and then I proceed to page 5. It is humbly submitted that the material evidence relating to the video footage is admissible and relevant in bail applications. It does not only demonstrate, in inverted commas, a strong prima facie case, but it may be used against the applicant in his subsequent trial to corroborate averments by the state. So as it were, as we're speaking now, there's no witness who testified about who killed, who robbed, who raped. And there's also lacking material evidence of a CCTV footage, which means, in other words, there's no witness, and the CCTV footage, which would have corroborated or strengthened the version of that person, is also missing. What are we sitting with? Zero. Zilch. Zilch evidence equals to zero. Nothing else. Now we proceed to mention, and we also would add that a zero sum of evidence means there's nothing pointing to Mahungela. Because there cannot be corroboration when there's no main witness. I mean, it's logic, really. Now we come to deal with Section 165 of the Constitution, dealing with issues about magistrates. we submit that magistrates are too often swayed by the clarity and confidence demonstrated by expert witnesses. Yes, let me stop at that. About the towers. My learned colleague produces a document. He's not an expert. He doesn't know how that document was produced, but purports to be relying on it as if it was a 212 statement. We don't have a 212, because 212 is a prima facie proof that what is contained in either report, it's just, it has to be received by mere production. So we don't know who authored it. We don't know when was it taken. He is not an expert, but has a nerve to say, at 7:15 you were at Sandton. At 7:35, I mean to say. 7:35 you were 100 meters at the back. But let me interpose once again, just on this version. The issue about 100 kilometers from the deceased is frozen. At no stage are we told that that distance is being minimized to 0. Up to now, it's still 100 meters, according to their version. Why? Video footage could have assisted in this regard. Can you kill somebody when you are 100 kilometers away from them? We respectfully submit, not at all. Can you rob with aggravating circumstances 100 kilometers from them? We submit, no. And same for robbery, for rape. But let's then digress. We have digressed a little bit. We're coming back to this one. Now, despite this, an expert witness is expected to be impartial and assist the court in justice. Selected photos cannot substitute the video footage. Selected photos by the prosecution and the IO. I could see how they were sifting, and we accidentally got M1 and 2, although they are saying we're not entitled to the contents of the docket. So they shot themselves in the foot. They are saying, come in. And the other authority, which doesn't change anything, says in bail applications they're not entitled to discovery. But M1 and M2, which comes from their own docket, when they realize that it's not supporting, because M1 refers to a different time, 10:03, and the M2 refers to no genital injuries, they say, no, we are still going to dig for some more gold somewhere. But for now, it may be an interim, but it is the only evidence before court. That which they are still going to dig, we don't know when are they going to get it and who's going to give it to them, but we have already alluded to the Honorable Court. It will definitely contradict if it comes with a different result. And we doubt as to whether it is going to be produced anytime soon. Now, we proceed to read. It is to be noted that if it had not been for CCTV cameras, which were silent witnesses to the attack, we refer to that case, the Mtetwa one, the death of the poor lady would have gone unnoticed and her killer would have walked free. Unaware of the fact that his actions were recorded, the assailant killed the poor woman continuously before he drove off, leaving her for dead on the pavement. It should be noted further, after found guilty of murdering the sex worker, his bail was withdrawn. I stop at that. It could have been a gruesome, kicking a poor lady defenseless. Bail was granted to this Mr. Mtetwa. It was only withdrawn after being found guilty, which must say to the state, a measurement for exceptional circumstances, even if they were to have a strong case against Mr. Mahungela, is entitled to bail. We submit. And this case shows that palpably clear. Pistorius also shows that, I referred to, and any other cases, but I'll deal with other cases to show. But in this one, we humbly submit that they have not only a weak, but hopeless and directionless case, which is doomed to failure. It is a stillborn, it's unfortunate, and it is not going to grow any further. Now, in this case also, Khumalo, the lady, died from the blunt force trauma, and according to medical evidence introduced in court, her liver was basically torn in half, so bad about this man. And I said, like Pistorius and Teto was granted bail. But why should it be refused in Mahungela's case, who is not linked by any silent witness or witnesses? We respectfully submit that this case be subjected to the same criterion of exceptional circumstances. The next paragraph will urge the Honourable Court to turn on its judicial microscope, if it has, we can provide if the Honourable Court doesn't have, to spot some inaccuracies, strange reasoning, and the poor grasp of the law by the state. Turned its blind eye to the crucial fact that the deceased was pregnant. It then begs the question, impregnated by whom? Was the relationship normal? Was she married? These are some of the questions which they're supposed to probe. Now they leave them because, no, they're excited about Mr. Mahungela, who's a young black boy here in Sandton, not for crime, but to further his studies. Then we further submit there is an obviously weak or mishandled part of the presentation of the state's case. The Sandton Sport Ground is a public place, and Bafana Mahungela is not the only public person who at some point was at the park. Where are other people? If they were there, why are they not shedding light about the real murderer? The post-mortem, in brackets PM, is used to establish the cause of death. It tells a different or contradictory story. My learned colleague, if he was that critical enough to see, the post-mortem says, person died because of 1, 2, 3. But it does not exclude. It does not say, it says, but does not exclude this and that and that. But that does not exclude. It may mean could have and could have not. There are some of the factual and legal deficiencies which inevitably make the state's case susceptible to prejudices against the applicant. Now, this is another case which is of crucial importance. And why do I mention it? I mention it precisely because it shows one important issue which is so relevant to our case. The time of death is of the essence. And may I also add that even in the Tetra case, there was this public outcry. Public outcry. In Scott Crossley also public outcry, but bail was granted. Scott Crossley versus S is 2000 SCA 127. It's a sad case, very sad case, and it breaks one's heart, where a black man was thrown into a lion's den to be fed to these animals. Now let's read what I have written, and I will deal with that. The SCA unanimously upheld the appeal of Mr. Scott Crossley against conviction for murdering Mr. Opachisale, whom he admitted throwing into the lion enclosure at the Mokwalo Game Park. The court found that the deceased was alive when this was done. Escort closely had assisted in the disposal of the deceased body with the intention of concealing the murder perpetrated by at least one of his employees. A conviction of being an accessory after the fact to murder was substituted. The court remarked that there was a vast difference between throwing an injured man to the lions with the intention that they devour him whilst he's still alive, and disposing of a dead body to conceal a murder that has already taken place. In particular, the evidence led by the prosecution was unreliable, as the eyewitnesses were accomplices and they had contradicted themselves. Now, in this case, why did I state this case? The court made it very clear that there is a vast difference between throwing an injured man to the lions, meaning the alive one, into the lion, and indeed it changes the charges. Same in this case. Cannot charge someone with murder against his viva voce evidence that I found this person being dead. Because you happen to have opened the rack, then you are the murderer. Doesn't follow. There's lack of the chain. As I said, 100 meters, and now the rack. Now, if you meet with a dead body, try to conceal that body. You become an accessory after the fact. You become an accessory after the fact if you knew the person who killed. This authority is of crucial importance in distinguishing between the time of the murder and the time of meeting the deceased body. And we humbly say, we have proven, there's no any other evidence, that we have discharged our owners. We gave you evidence and never let an affidavit deposed. And the court, we urge the honorable courts to take that into account when it evaluates the evidence. Now, let me proceed to mention this, that the state has to have a pretty good idea and significant enough points to warrant mention. The standard by which courts are to carry their role, it is the standard which is required from magistrates, the same as the one applied in trial courts regarding impartiality and fairness during proceedings. The court is to base their finding on the evidence led and nothing else. And this was reiterated clearly in L versus Majali. It is a high court matter here in Gauteng, and it emphasizes that the bail inquiry is a judicial process that has to be conducted impartially and judicially, and in accordance with relevant statutory and constitutional prescripts. Nothing else. About who's purple, grey, middle back or no middle back, no. This is clear. We further state that it must also be appreciated that the constitutional right to a fair trial includes proceedings such as bail proceedings. Fairness and the constitutional right to a fair bail hearing are manifestly under threat where bail magistrate like the one in Kobese compromise her impartiality by making remarks and observations, which she did in the course of an extempore judgment. Now, we are very glad that the court didn't behave like the Honorable Court in Kobese. It acted like any other judicial officer presiding over a trial who should conduct this bail hearing open-mindedly, impartially and fairly, and that the court must be applauded for that kind of behavior. Now, we mentioned at paragraph 21 the most egregious comment. Now I leave that. Now let's get to Scott Crossley. Scott Crossley, on the other hand, at the foot of page 6, is of crucial importance because it says what? At paragraph 30, that a judicial officer should not be biased or resort to stereotyping in court, from which unfair and unwarranted generalizations might be made. Such generalizations were to be avoided in judicial reasoning, as they were apt to result in a miscarriage of justice. A close quote. We quote, going further, that other courts has previously warned that magistrates are not rubber stamps for investigating officers or prosecutors' views regarding whether bail should be granted or not. And I refer to as versus Joone, 1973 1 SA 841, Cape Town 847 A to C, close bracket. The court in Joone remarked that a strict independent assessment of the facts of each case, which would include a careful consideration of the circumstances of each accused, the severity of the crime and the interest of the community by the presiding officer in each case, should be done. A court hearing a bail application should not be a passive umpire. Now I wish to comment about this one. My learned colleague, I can vividly recollect, whilst he was on and excited about his cross-examination, noted that the father of Bafana Mahungela was in court. At all relevant and material times, he was sitting with the IO next to him, and even said he's taking notes from the IO. Now one wonders, if Section 63 were to be invoked by this honorable court, that he should be called into the box, what were we going to do? I'm saying that just to show that which is goose for the gander is goose for the what is goose for the what is whatever. What is what?
Good for the goose.
What is good for the goose is good for the gander. But thank you very much. Now, according to him, some people must get out. But his own IO, who is giving him notes, he has to sit. 63, 6010 says the court may want to clarify some issues and call any other witness, come in. That didn't dawn. Never at any point come to his attention. So, but I'm simply saying, he who lives in a glass house must never ever throw stones. Now, on all this, we're saying section 17, we humbly submit that section 165 of the Constitution refers to independence and impartiality. The court has to take heed of what Head AJ expressed, that where the state has presented a reasonably strong prima facie case against the appellant, and that the appellant would have a lot of explaining to do, this would of necessity constitute a weighty factor in assessing the merits of a bail application. In other words, critics must understand that we've also followed the Honorable Whitehead in this, because we knew this viva voce evidence was to be a weighty factor to be taken into account. Proceed to read. We draw court's attention to the fact that cross-examination can expose a bad story. It can expose a lack of knowledge. It can make a liar out of an honest person. And he failed to make a liar out of this honest Mr. Mahungela in his cross-examination. And if I'm wrong, he must stand up and tell us what has he proven which is right. The court saw Mr. Mahungela twice on that stand as he was subjected to grilling, cross-examination, and he came out just strongly as he did on his direct examination. He has no faintest idea of the deceased's life and never met her. State case at its highest mark puts him on the scene 100 meters away from the deceased, and even today there's a lack of evidence to reduce the distance. I've mentioned that they are both static. On the issue of merits, and more particularly regarding the strength of the state case, our client, we would humbly submit that our client, the applicant, has discharged the honors of proving exceptional circumstances by using strong, independent evidence pointing to his innocence. He was tested when he was presented the view-of evidence. It is then for the trial court to assess the weight to be attached thereto in the light of all the evidence. Your worship can also look at S versus Peterson at page 12. Then we also refer the Honorable Court that in the matter of S versus C, 1998 in bracket 2 SACR 721 KPA at 724 H2I, the English translation thereof of the head note reads, the court held the following: it could not have been the intention of the legislature that an alleged offender must be detained when he has established conclusively that he will attend trial, that he will not interfere with the administration of justice, that he will not commit no further wrongdoing, i.e. the usual circumstances that arise in consideration in a bail application. As soon as more is required of him, the procedure becomes punitive. That could be altogether objectionable. Therefore, all that the legislature enacted somewhat clumsily is exceptional care when considering the usual circumstances. The court must be able to hold with a greater degree of certainty that the detainee will do all that his bail conditions require of him. That is all that is said in SVCC. Now, we have to submit that indeed what the state is doing now, it's a procedure which is punitive. Punitive, I've mentioned S versus Atchison. Punitive in that even now, in their heads of argument, they don't tell this on record and take it into their confidence. Which other evidence is outstanding? We don't know. We're in the dark. But they're saying, for as long as you don't know, we don't care. We'll continue investigating. You stay in the dark. We don't care as to whether you stay in dark clothes, in a very dark place, infested by rats and other things, eating poor food. We don't care much. Stay. That on its own is punitive. About the postponement, we don't worry. At least today we are here. We knew that this day will come what may, inevitable. Now, why would it be punitive? Being punitive will be acting contra constitution. Section 1012, founding values, as I said, and 36 says limit when it's reasonable and justifiable. But to hold someone in detention pending investigation as to whether they are going to move at a millipede pace or snail pace, they know better. Now I am on page 8, Your Worship, paragraph 4. This is important, very important to us. Prosecutors and police, an unholy union. An unholy union which continued to persist even in Christmas time when Jesus was born. And at the time when Jesus was born, my client was in custody with nothing. But we state as follows. We state prosecutors work with police day in and out, and typically they are reluctant to criticize them or investigate them. This bonding leads to tunnel vision. What is tunnel vision? Tunnel vision in the criminal justice context can be described as a tendency of participants in the system, such as police or prosecutors and laypersons, including experts, to focus on a particular theory of a case and to dismiss or undervalue evidence that contradicts that theory. This mental process leads to unconscious filtering of evidence that will build a case in inverted commas against a particular suspect, while ignoring or suppressing evidence respecting the same suspect that tends to point away from guilt. I close the quote. In other words, it's a conspiracy which is biased, turning its eyes on reality and decides to hallucinate. This quote comes from an article which I got from Google, which is Innocence at Stake, the need for continued vigilance to prevent wrongful convictions in Canada. And I have the citation of the thing. Now, I continue to submit moral compromise and bias by both meaning the police and the prosecutor, faces duty of being extreme by the prosecutor, faces duty of being extremely vigilant and willing to challenge the investigation in order to guard against the effects of tunnel vision. They both hold the same. They both hold the same hymn book and collectively sing the same tune, the same lyrics, same tempo, and with the same baritone voices from the same hymn book. Their duet continues until they are voiceless but holding the same book, as in this case. Now, I further read from the Rebus an article, Who Takes the Blame? Liability of the Minister of Police for Unscrupulous Conduct of his officials. Now, it says, it is important that the officials, as the investigators of crime, take their constitutional duties seriously and place all relevant and necessary facts before the court for the proper administration of justice. Police officers should be morally upright, honest, and diligent in the performance of their duties. Generally, it should be easy to trust that a police official will not break the law, will not manufacture evidence against innocent people, nor will they conspire and connive with criminals to defeat the ends of justice. Now, in this case, can it be said that indeed all the relevant and necessary facts were put bare to the court? No. M1, M2 clearly shows. The manner in which they conducted themselves throughout, from the beginning to the end, I think deserves less to be said about. Can it be said that both the prosecutor are morally upright, honest, and diligent? It cannot be. They are sharing notes instead of doing proper investigations and ensuring that justice at the end of the day prevails. Now, I proceed to mention delving into the mental state of a criminal, however, is considerably more difficult and often impossible. And criminals, like ordinary people, are creatures of habit. We have shown by character evidence that you are sitting with a young boy, no previous convictions, no warrants, nothing. Even on the day he slept, he takes blame, slept in the taxi. Hence, I landed in Parkmore. When the taxi driver said, I'm not taking you back to your place of destination, never argued with the driver, never fought with the driver, could have used that unknown object to create a head trauma to the driver. But he didn't have it. He decided then the best in this circumstance is for me to walk. I have myself to blame. Is that person not honest? in our view, he is. Now, we continue to state, sadly in this case, the investigating officer acts in common purpose with the prosecutor and others, failed to observe the constitutional provisions regarding the rights of the arrested and detained Mr. Bafana Mahungela. My learned colleague never disputed the fact that the police, upon arresting, they were hitting. To him, sounds like a very good tune. They were supposed to do it. And what I know as being a prosecutor before, prosecutors are meant to be gatekeepers of justice. But this gentleman, with the greatest respect, decides, no, continue hitting them, they deserve it. Even in cross-examination, even though he was sitting next to the investigating officer, they never disputed. It remains unchallenged, a version that my client was beaten. Because why? They were trying to torture, extract a confession from him. Now, I said this document about who is to blame. It's written by Andrews J. Swartz, arrest without a warrant. And they never had a warrant, of course, I wasn't forget that. What requirements must be observed by peace officers? It's in the rebus, October 2023. Yeah, I mentioned that it puts it succinctly, that section 13 of the SAPS Act 1995, Police Act in brackets, states that subject to the Constitution and due regard to the fundamental right of every person, a member may exercise such powers and shall perform such duties and functions as are by law conferred on or are assigned to a police official. It is clear from this provision that police action can only be legitimate if there are laws governing such action, should it be in line with the Constitution. I cite the case Lapane versus Minister of Police, 2014, the Pretoria High Court matter. It's in fact a Limpopo matter at paragraph 29. Now, even the act which governs the police spells out as to peremptory. It is not, doesn't say may, shall. So interpretation of statutes should have been known by both the policeman and the prosecutor. I proceed to read that the court held that there is a constitutional right in Lapane, the constitutional duty on the police officers and the public prosecutors who are handling the case to ascertain the reasons for further detention of the suspect, and the prosecutor to place such reasons or lack of before the court. And also, I can remember a matter which is Duplessis, Minister of Police versus Duplessis, which also spells out prosecutors must place matters on the roll after reading and being convinced that the docket, the facts in the docket constitute a prima facie case. But in this case, it was just, let's just move it. Just move it. And we'll see. Now, simply being in the vicinity of the deceased body does not justify the arrest and detention for such a long time of approximately a month. The preamble of the Police Service Act states that one of the functions that must be performed by the police officers is to combat crime, not to be selective. To effectively discharge this duty, they must be equipped with the necessary powers to do so. Some of the powers include, but are not limited to, arrest, interrogation, is bungled, investigated in a very perfunctory manner. It's a cursory investigation, and it's again a sloppy investigation, which leads to a shoddy prosecution, which ultimately results in wrong conviction or wrong refusal of bail, and that is why we call it a delusional mystery. Now I proceed to paragraph number 5, prosecutorial discretion. I quote a case which is in the US. It's Attorney General versus TEFS, 239 Mass 458. It will be backed by S versus Federal versus Dazen as we go down. It quotes, the great powers and great responsibilities of the office of the district attorney demand that the incumbent of that office be of a character incorruptible, a reputation unsullied, a standard of ethical a high standard of ethical professional ethics and sound judgment of no mean order. Close bracket. What we experience here, what we observe here, what we hear from here is pettiness, nothing else. And if you're petty, you're controlled by emotions. And if you're controlled by emotions, you're irrational. And if you're irrational, you're arbitrary. This is the kind of prosecutor before us. And indeed, the question about reporting, I am not going to be in pains. I shall take this record as it stands, hand it over to the relevant authorities, and they will decide. As to whether they come back favoring him, then they would have set their standard abnormally low. Because they would be condoning gross incompetence in a bail application. So one wonders, if gross competence is displayed in a bail application, what about the trial itself? Now, I refer, Honourable Court, to Section 1794 of the Constitution, which provides, and I quote, national legislation must ensure that the prosecuting authority exercises its functions without fear, favour, or prejudice. The national legislation concerned is the NPA Act 32 of 1998, the NPA Act. Two sections of the Act are relevant for present purposes, namely Section 32 and Section 22(6). The former section provides 1A, a member of the prosecuting authority shall serve impartially and exercise, carry out, or perform his or her powers, duties, and functions in good faith without fear, favour, or prejudice, and subject to the Constitution and the law. The oath and affirmation prescribed in subsection 2A of the same section contain the words, enforce the law of the Republic without fear, favour, or prejudice. Section 22(6) of the NPA requires the National Director of the Public Prosecution, in consultation with the Minister and after consultation with the Deputy Directors of Public Prosecutions and Directors, to frame a code of conduct and provide that such code shall be compiled with by the prosecuting authority. The code of conduct for members of the NPA was published in the Government Gazette 33907 on 29 December 2010. It contains the following provisions relevant for present purposes. B, independence. C, impartiality. Independence means prosecution has to be independent from the police. Independence means police have to be independent from their prosecution. But here, no. They gang with other forces, and then they come up with the poor product which they're producing, which they say, according to their poor submissions, bail should be refused. We do not agree. We are in substantial disagreement with them. I also refer them as if the NPA Act was not enough. My learned colleague must be knowing this. The United Nations guidelines on the role of prosecutors, adopted by the 8th UN Congress on the Prevention of Crime and Treatment of Offenders in Havana, in Cuba, on the 27th August to 7th September 1990, as well as the standards of professional responsibility and statements of the essential duties and rights of prosecutors of the International Association of Prosecutors. I refer to clause 13 thereof, impartiality, public interest, interest of the community in general. Interest of justice does not refer to a particular group. It refers to everyone. 5.1, role in criminal proceedings. Prosecutors shall perform their duties fairly consistently and expeditiously. In the institution of criminal proceedings, they will proceed only when a case is well-founded, upon evidence reasonably believed to be reliable and admissible, and we will not continue with the prosecution in the absence of such evidence. Throughout the course of proceedings, the case will be firmly but fairly prosecuted and not beyond what is indicated by the evidence. Vanaf Westhuizen, Durevat, there's a case Durevat where there's the sunflower case. Also, it refers to public. What is this public? What? Yeah, public outcry, where two white men, it is alleged, killed a 9-year-old black boy, and we know they were granted bail. We know they approached the SCA, and their conviction, which relied on a single witness, Mr. Pakisi, was reversed. And we say, justice well done. Ledowa J, and I'll refer to Ledowa J, is the one who led in the judgment, but I respect his judgment fully. But what I would prefer to refer to is what Justice Punan referred to. And he referred to an article which dealt greatly with, and I quote him, prosecutors should bring professional standards of a non-partisan nature of the prosecutorial discretion. It is clear that prosecutors must pay meticulous attention to police dockets before deciding whether or not to prosecute, and in this respect must act with objectivity. A sensible, inverted, and circumspection should be exercised by the prosecutor in deciding to use it. After all, it is excellent to have a giant strength, but it's tyrannous to use it like a giant. A prosecutor should be just a prosecutor, not a persecutor. Now, I am going to then move on to exceptional circumstances. I'm going to skip that in paragraph 11, which deals with the prosecution policy and the ethics, a practical guide, because it will show. And that the prosecution's discretion forms the cornerstone of prosecution. Let me move to exceptional circumstances. Now, I was told that exceptional circumstances are referred to only two things. I have already mentioned that investigations, or let me start by saying this. This authority, which is very clear, that once accused has shown that the state case is poor, is weak, and that in the subsequent trial he will be acquitted, that on its own constitutes exceptional circumstances. Now, once accused shows that I'm facing very serious offenses against me, I need to have time to can consult. And I referred to all this. I don't know, that's why I'm saying 94, I guess. Is it 94? As to what constitutes. I referred to all this, and I showed that, and I said to this honorable court, in page 99, in the bail guide, practitioner's guide, it's in S versus C, it says ordinary circumstances can be treated as exceptional circumstances. The likelihood of acquittal as exceptional, because the state case is weak and he will be acquitted. And I also mentioned preparation of defense as circumstantial due to the seriousness of the offense. Now, I am, where is it? Okay, it's fine. I'll do that. Now let's proceed. Now I'm submitting that it is not correct that I only referred to witness and therefore that viva voce evidence has been tendered. I never said that. Please, may it be corrected for the record. And we know for a fact that exceptional circumstances are indefinable or undefinable. Now, and we know that there are two schools of thought. Others are saying unusual, extraordinary, da-da-da-da-da. And others are saying ordinary suffices. Now, each case has to be looked at in accordance with its peculiarity. It depends on the context and on the particular circumstances of each case under consideration. There's no fixed rule that all Schedule 6 are banned. Do not, if they have that policy, it should be shown to us, or if it's law, we would like to read it. And I've shown that in all these cases which I have mentioned, Durevad, Pistorius, Mtetwa, and so on and so forth, they were on affidavit. Now Mohammed explains it very nicely. It says, exceptional circumstances may, of course, mean different things to different people. So that allowance should be made for a certain flexibility. Which flexibility in the judicial approach to the question? It's in Mohammed. In essence, the court will be exercising a value judgment in accordance with all the relevant facts, evidence, and circumstances, with reference to all the applicable legal criteria. In Maseko, I have referred to Peterson already, in Maseko versus State, the High Court in Johannesburg also, and see also Twala, this is the State Appeal Court in Pretoria. Bail falling within the ambit of Schedule 5, the appellant was at the time of his arrest on parole. The other one was on appeal. But that in itself does not presuppose that he has to be banned from getting bail. Because the presumption of innocence still exists, be as tenuous as it is, until it's proven otherwise. We must remember, I shouldn't gloss over the fact that my client has not been found guilty. And why further detention? Now, at this stage, Your Worship, I can inform Honourable Court that we were given the affidavit this morning. I wish for a short adjournment, peruse and see what other issues I need to deal with, because I've realized in this affidavit there are personal attacks, but I am going to exercise professionalism, civility, and integrity. I'm not going to stoop. As my learned colleague has said earlier on, I'm senior counsel. I should behave like one. May I ask for this adjournment?
The matter will stand down. Mr. Bakano, I know there is a new matter. Did you receive it?
Magistrate calls case number RC. Page 49 of the Ivan Mukheti Yekit is in custody.